Test. Judge microphone 1. Judge microphone 2. Judge microphone 3. Judge microphone 4. Judge microphone 5. Judge microphone 6. And judge microphone 7. Appellant mic. Check appellant mic. And appellee mic. Check appellee mic.
name is you before the Honorable Justices of the Supreme Judicial Court of the Law Court of Portland, within and from the state of Maine, may come forth and declare it, and it shall be heard.
Good morning, you can be seated. And the matter before the court is BCD 25-327, Preservation Bath versus City of Bath. We are being streamed on the web both by video and by audio. And before we begin the argument, I'd ask counsel to identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Good morning. Patrick Lyons, representing the appellant Preservation Bath. Thank you.
Good morning. Daniel Murphy for the City of Bath.
Thank you. And Attorney Lyons, if you're ready to proceed, we're happy to hear your argument.
Thank you. Good morning. May it please the court. The 2023 Bath Comprehensive Plan was developed over 5 years using a robust public engagement process that reached hundreds of citizens through numerous meetings, workshops, interviews, and surveys. Following a positive recommendation from the state of Maine and the Bath Planning Board, the City Council unanimously adopted the plan. Maine is experiencing a housing crisis. Like many communities across the state, lowering barriers to housing and promoting housing development are key priorities for Bath, as was established in its 2023 Comprehensive Plan. The Maine legislature has made clear that zoning ordinances must be pursuant to and consistent with the comprehensive plan. This is good policy. It prevents piecemeal legislation and development and ensures land use ordinances actually reflect a community's long-term vision and collective priorities rather than reactionary and short-sighted decisions. Unfortunately, by way of a citizen's petition, the comprehensive plan's housing goals were thwarted by a group of golfers that feared housing construction would limit their ability to play a full 18 holes of golf. Following the City Council's unanimous decision to reject the petition proposal, the voters of Bath voted to remove the ability to develop any housing in the golf course district. This reactionary, ill-informed vote failed to consider and was inconsistent with the spirit, goals, and plain language of the comprehensive plan. To find otherwise would render the Bath Comprehensive Plan toothless, notwithstanding the legislature's clear intent that such plans be binding and enforceable. Thank you.
Can you tell me a case in which the law court has found an ordinance inconsistent with the comprehensive plan?
Inconsistent with the comprehensive plan? I cannot off the top of my head, Your Honor.
Because there aren't any.
That may be so.
So can you tell, doesn't there have to be a concrete inconsistency? And comprehensive plans like this one seem to be mostly precatory with big ideas. So how can you ever be inconsistent with a comprehensive plan that is focused on goals and competing policies?
Well, I think this case is a great example, Your Honor. While if you look at the goals in general, right, there are certainly goals about housing, and there, as pointed out by the city, there are goals regarding climate resilience. But when you actually look at the plain language of a comprehensive plan, that's where you can find inconsistencies, as is here. The plain language of this comprehensive plan says cluster developments are permitted in the golf course district.
Let's talk about that, because it does say cluster subdivisions are also allowed in this district, but that's in an appendix to the plan that appears to be describing the current state of the land use ordinances at the time the plan was developed. So is it really fair to say that that's sort of incorporated into the general plan as a goal or a mandate, or is it really just a description of the land use regulations as it existed at the time the plan was adopted?
I believe it's both, Your Honor. It is a description of the permitted land uses at the time in the land use code when the comprehensive plan was adopted. But I also think it's important to note that last sentence regarding allowing cluster developments, that's not the only form of housing that was allowed under the land use code at that time.
So it simply may be an inaccurate or incomplete description, but it's still in an area in the code that is containing a description of existing uses.
Certainly, Your Honor. I don't know if I'd call it inaccurate. I would just say that that language and that specific use was chosen for a reason. Also, if you read that paragraph, again, this is a policy, it's a policy statement, not just a description of what uses are in there. The golf course district is designed to protect and allow for golf, but also to protect uses from encroaching from outside the district or from the district's uses from encroaching on the rural residential area around it. Those are clear policy determinations that the city, through this process, determined that were important to note that were in there.
We usually think of comprehensive plans as sort of painting in broad strokes, some sort of generic concepts, aspirational goals, and things like that. We don't usually see it as laying out very specific ordinance details as part of it. And we've said that we review comprehensive plans as a whole, and we'll conclude that rezoning acts consistent with a comprehensive plan when it's in harmony with some provisions of the plan, even if it appears inconsistent with other provisions of the plan. So it seems odd to say, we want to maintain this, we want to maintain that. And oh, by the way, this particular situation here must be X, Y, and Z, which sounds more like an ordinance. Isn't this circumstance where we'd be saying they're broad strokes, that the plan wants to preserve the operation of the golf course, and that this side mention in an appendix to the particular housing issues really isn't part and parcel of the generic philosophical purpose of the plan?
Well, Your Honor, I believe if you look at the plan, the first goal it points out, and it's 4 big goals, is housing. Reading that plan in a whole, as it was pointed out in my brief and in the record, it clearly over and over states that the priority here is we need housing. We need housing for our workforce. BIW employees are commuting over an hour to work there. People can't afford to only less than 50% of people can actually make the median income that can have housing in Bath. So in that sense, Your Honor, I think there are clear statements in this comprehensive plan that housing is important. Couple that with a statement in there saying cluster developments are allowed in this golf course district. Again, I understand, Your Honor, that yes, this is a comprehensive plan, say a lot, but what does it mean if the legislature has said that land use ordinance must be consistent with and pursuant to a comprehensive plan? If you have language in a comprehensive plan that clearly says this type of use is permitted, why couldn't another municipality go further and say, here's what we want to have prescriptively in our ordinances?
Well, the plan here says sort of generically that affordable housing is good. We should encourage affordable housing. But it doesn't mean every ordinance must be approved if it provides for or opposes housing.
I agree, Your Honor. But I would say in this instance, if you look at the circumstances here, is that this proposal went before the Bath City Council. There was one meeting. It unanimously rejected this proposal. Then, without any further process, no further meetings, no citizen participation, it goes to a vote.
Yeah, but don't we assume, I mean, we've really said that in a citizen initiative, we will presume essentially that means that the citizens found that it is not inconsistent with the plan. I mean, I understand that, but that maybe the city council didn't want it, but citizens adopted it.
The citizens did adopt it, but I would say the citizens adopt it under the understanding of what was before them, which had nothing to do with, there was no discussion of this is consistent with the comprehensive plan.
I understand there was no discussion, there wasn't a public forum, et cetera, but I don't think that under our case law, we've not said that that's necessary. We're just going to presume, essentially. It is an assumption. It may be a fiction, but it is nonetheless an assumption, right? That if it went to citizen initiative, we assume they did not find it to be inconsistent with the plan. And our job is then to say, could they have found that?
Yes, that is what the case law says, Your Honor. I would say in this circumstances, it justifies the opportunity to clarify that in these circumstances, there should be some form of meeting and discussion or some form
Well,
of information.
I have a hard time understanding the whole concept of why you would ever look, whether it's passed by a citizen initiative or it's passed by a town council, why you'd ever look beyond the comprehensive plan language and the ordinance language, because the test is whether they're inconsistent. So what kind of extraneous fact-finding conclusions would be relevant to that determination? Don't you look at the comprehensive plan and you look at the ordinance and then you look as a matter of law to determine whether they're inconsistent? And why would it make a difference whether it's an initiative or it's a council passing the law?
In this instance, in your role, Your Honors, as when it gets to this point, you're correct. You're looking at the facts in the record and you're looking at the ordinance and the comprehensive plan. What I'm getting at is that the process getting there should be improved, and this is the opportunity to improve it, to require otherwise you have a perverse
You don't
incentive.
have any authority to say, oh, town, if you're going to do a citizen initiative, you need to have a public forum, or you need to do this. I don't think we have any authority to do that.
I think you have the authority, Your Honor, to require a
Rewrite
certain
their-
level of process in order to
There
ensure-
was process here, in a sense. I mean, initiatives require votes. Votes typically, there are campaigns, there's a pro and a con. It's not on the record, obviously, it's not in the record, but I assume the citizens of Bath had an opportunity to talk about this and decide what they wanted to do. And they clearly knew if they were going to pass this initiative, it was going to prevent or at least hamper housing development in that district, didn't they?
Presumably, Your Honor, yes, but I would say, taken out of the context, that there was no reflection on a 5-year comprehensive plan process that they went through. There's no evidence that, basically, the comprehensive plan is thrown out the door.
Well, the evidence is that they didn't like what the city council did. They took the initiative, they took the thought before the city council. It wasn't approved. They didn't like that and acted in a legislative manner to arrive at the end that they thought was appropriate, consistent with the comprehensive plan, at least based upon the presumption that the chief alluded to.
Your Honor, that is what the record shows, but I would also, I think, ultimately, again, if there's nothing required to actually, after 5 years, that put forward a comprehensive plan, and then without any further reflection that can be evidenced, I mean, we can make assumptions about what people said, but having minimal process to ensure that the legislative body considers whether or not this is consistent with the comprehensive plan before voting, I believe this is the instance that shows the need for that.
Thank you.
Thank you.
Attorney Murphy?
Thank you, Your Honor. May it please the court, Daniel Murphy for the City of Bath. This appeal concerns amendments to the city's land use code enacted by the city's voters in 2024 that restricted cluster developments and multifamily dwelling developments in the city's golf course district. Appellant Preservation Bath is the operator of an 18-hole golf course in the golf course district. It has challenged these 2024 amendments, asserting that they are not in harmony with the city's comprehensive plan and are void. The city respectfully disagrees. This court should reject Preservation Bath's arguments and affirm the judgment of the Superior Court because under applicable law, the city's plan has no regulatory teeth and only serves as an overarching goal and policy-oriented document. In contrast, zoning ordinances, including the 2024 amendments, have regulatory force. These two documents need only strike a reasonable balance among various goals and need only have basic harmony. A zoning ordinance can be consistent with a plan where it serves some plan goals but seemingly clashes with others. Importantly, the 2024 amendments are in harmony with the plan. The sole paragraph in the plan that addresses the golf course district at A149 shows complete harmony between the 2024 amendments and the plan. This relevant paragraph actually states that the golf course district is designed to maintain the Bath Golf Club golf course operation. It speaks to protecting the golf course from incompatible neighboring land uses and encroachments. It notes that the district allows for the golf course to expand, not contract. And it also notes in the present tense that cluster developments are also allowed in this district. Preservation Bath takes this last statement as an edict that cluster developments must remain permissible in this district forever. However, plans are not regulatory documents. They do not have the command of law in the same manner as a regulatory document such as a zoning ordinance. A present tense statement in 2023 cannot be transformed into an edict as to future rights in later years. It cannot be used to curtail the voters' right to enact legislation. In all other respects, Preservation Bath relies on only generalized statements from the plan concerning the City of Bath's broad goals concerning housing development in the future. Not one of these statements is specific as to future developments of housing in the golf course district. Rather, the plan only expresses generalized goals of protecting the golf course, not shrinking the golf course. Elsewhere, the 2024 amendments are harmonious with many portions of the plan. These were highlighted in pages 19 and 22 of our brief. They include making the city climate resilient by identifying and conserving important natural areas that provide benefits for open space, recreation, and climate resilience. Housing in the golf course district would reduce open spaces, reduce recreation, and reduce climate resilience because of the reduction in green spaces. There are other areas of the plan that also...
The green light is on, so let me ask this hypothetical. Understanding that is not this case, and setting aside grandfathering issues, could the, whether it's passed by the town council or it's passed by the people, could they eliminate the golf course and say, you know, if in favor of more housing and more climate resilience, we think we want to get rid of the golf course and put housing on it instead?
That's a difficult hypothetical because it's so sweeping.
That's why I asked it.
Yeah.
You can tell she's tired of attorneys saying, but that's not what happened here.
Well, it is so sweeping. You know, you'd have issues of vested rights, whether...
Grandfathering aside.
Yeah.
I mean, if a comprehensive plan is just a series of goals, big ideas, and it doesn't really have any regulatory teeth, then why can't the people or the council say, you know what, we think it's time to get rid of this golf course, and so we're going to, you know, taper off its use for grandfathering purposes?
I don't disagree that harmony is required. So if the plan said that it's imperative that we have housing in the golf course district, you certainly could have a zoning ordinance that said the same.
So if there were concrete language in the comprehensive plan itself that wasn't squishy policy and ideas, but it said, whatever happens, we got to keep this golf course
or
in
eliminate
that
this golf
district.
course, or eliminate it. I mean, it could be either. It could be either. But my point in this case is that there's perfect harmony between the plan and the zoning ordinance. If you actually look at that paragraph at A149, the sole paragraph that addresses the golf course district, it essentially says that we need to protect and preserve the golf course district, that we're here to enhance the operations, not shrink them.
But there is concrete language in there that says cluster subdivisions are also allowed in this district.
Yes,
Pretty
in that
concrete,
sentence,
isn't it?
we've sparred over that sentence, and of course, to me, it's very important that it uses the present tense. It describes the state of facts in 2023. They were permissible at that time that the plan was adopted in 2023.
That's why it refers to an inventory, correct? It's what exists at that moment.
In Appendix A.
Yeah, there's no must or shall or forever shall. And if it did say forever shall be available for development, that would be improper because you can't bind a current city council.
Well, you can bind it to the comprehensive plan.
Yes, I agree with you
So
with
they
that.
just have to change the comprehensive plan first.
Yep.
Can I ask back to your argument? I'm really struggling to understand the argument about how this is consistent with the comprehensive plan because it's promoting climate resilience and stewarding natural areas. Golf course is not a natural area, and in fact have a whole lot of usually runoff and fertilizers and a whole lot of other things. I mean, I really struggle to understand that argument.
If you look at A147, there's a passage concerning the New Meadow Rivers, and they identify residential land use and roads as non-point pollution sources, that when you have the development of housing and you have roads, those are sources of pollution.
And the golf course isn't?
Well, I don't know the extent to which, is it a natural golf course? Does it
Well,
use
Natural
that-
golf course?
do we need a record on this issue? And that's what I was struggling with. I agree with the chief that I can think of all sorts of reasons a golf course might not be climate resilient, but that's just me musing. The stipulated record here is really silent on the climate impacts of the golf course. So how do we accept your argument that it promotes climate resilience?
Well, that argument is one of at least 4 from the plan where there's harmony. So you also have the, at A136, the big ideas of conserving areas that provide benefits for open space, recreation, and climate resilience. And so a golf course is an open space. It's a source for recreation. It is a natural area. It's green. It has grass. It has trees. It's a lovely golf course, actually.
I think a lot of landscapers would probably tell you grass is very unnatural. It takes a lot to grow grass, particularly on a golf course.
Yes, but it has more natural matter in comparison to, say, concrete or pavement. It's permeable. That's a wonderful benefit, that it actually can absorb water.
Usually
But
it's fairly monoculture in a golf course, but that's okay.
beautiful trees. It's a gorgeous golf course. At A138, there's also the passage with respect to rural areas, preserving view sheds, restricting land use, preserving rural landscapes, scenic views, natural resources. And I think it is important that there's not a lack of harmony in relation to the plan and the zoning ordinance, that there's nothing in the plan that says we must develop housing in the golf course district. On the contrary, it says the opposite.
Going back to the provision Appendix A and that troublesome sentence at the end that we all are struggling to interpret. As I look at the entire text of that section there and try and draw from it a policy that the plan is laying out there and trying to understand what's happening there, it's pretty clear that there is a policy being established to protect the golf course operation from incompatible neighboring land uses. They don't want encroachment by particular developments there. And as far as the district itself applies, the fact that cluster subdivisions are allowed there does not undercut the policy of protection that is laid out in the earlier paragraphs there. I don't necessarily understand or buy into the present tense argument you're making here, but I think what this section is saying, we got to protect this, and cluster subdivisions are not going to threaten it, that they're okay, that is not locked into one period of time. Am I off base on that?
I think at that time, that was the determination of the city council, the town. But to me, that present tense verb is very important because it's describing a state of facts. It's not a command. It's not an edict. Even under applicable law from this court, plans do not have regulatory teeth.
But it's also saying the protection of the operation is not threatened by cluster subdivisions. That's how I'm reading that.
I think that's perhaps reading a lot from my viewpoint, but I think it's saying that they're allowed in the district.
Are comprehensive plans adopted directly by the voters?
That's a good question. I don't have the answer to that, Your Honor. I'm sorry.
If it were, then would the citizen initiative effectively be an amendment?
No, I don't think so, because the difference between the plan and the zoning ordinance, I just think that they're
No, an
different
amendment to
things.
the plan. An amendment to the plans on A149 that cluster subdivisions are also allowed in this district.
I view that as part of the plan.
Correct.
Yeah. Yeah. So I do view that statement as part of the plan, which is to be read as a whole. I did want to raise one issue with respect to the evidentiary process, because even in Preservation Bath's brief, they acknowledge that there was a public meeting, there was a public hearing. At A161 and 162, there are minutes that reflect this public meeting concerning the discussion regarding consistency between the plan and the zoning ordinance. So
Does it
there was a
matter?
public process as required by law.
Does it matter?
Yes, it does. Yes, it does, and it happened. Under Section 30A MRS 4352(1), it's required that you have to have a public process, and it occurred. There's been no challenge that it didn't occur. It's been acknowledged in their brief. So I want to just make that point, that it's not that we're assuming that there was a public process. It actually occurred. There was debate. It's in the record, A161, 162. And so I did struggle with that discussion in Bog Lake where it said that the task of the court is based on the evidence to determine whether the legislative body could have rationally decided that there was harmony. That could have decided as opposed to did decide. And so it is sort of like a hypothetical.
Well, but isn't that language somewhat necessary when we're talking about a citizen initiative? In other words, it's not like we have the citizens who voted in favor of the ordinance telling us what their deliberative process was before they voted.
I agree. I agree entirely. But that statement could have, what that means is that you can look at the documents, as Justice Connors mentioned, you can look at the plan and the ordinance and see whether there's plausible harmony. And if it exists, then you defer to the action of the voters.
Can you conceive of a situation, going back to Justice Connors' opening question to Mr. Lyons, where, because these plans have often competing goals, where we wouldn't find it in basic harmony? It seems we haven't done it before. It seems to me, sort of under the argument you're advancing, everything's going to be in basic harmony with a comprehensive plan.
I believe it's possible to have a lack of harmony. It just is not, the court hasn't seen it just yet. But if the plan actually said that we are designating a portion of a municipality for development, and then there was a zoning ordinance passed by citizens that said you can't have any development, it would be lack harmony. It would not be consistent. So, but there are very few plans that have that should language or must language.
So it would require, in your view, a plan that's very prescriptive about a particular type of land use in a particular area?
Yes, yes. But I think there are municipalities that would say that, look, we have a part of town that we want to develop, maybe in Portland, down in Marginal Way. That's an example of that, where a town or city has said, we want to develop this area. We have certain approaches. Maybe there's a streamlined approach or something like that. And if that's incorporated into the plan with sort of mandatory language, should, must, then the ordinances must be consistent with that. It just does not exist here.
Thank you.
Thank you, Your Honor.
And Attorney Lyons, you reserved a few minutes for rebuttal.
Thank you, Your Honor. Yes, a few points. Golf courses are not natural areas. Cluster developments are designed to preserve natural areas.
They're open space. They have scenic views. That's why people pay so much for the houses next to them. And isn't open space and scenic views a part of what they're trying to preserve in areas in the town?
And recreation.
Certainly, Your Honor. They are, but at the same time, there are no houses next to this golf course because there have not.
It's open space.
Yes, certainly open space. There's a variety of open space, Your Honors. And I would just note that cluster development is designed to, you're allowed to develop on a smaller area of smaller houses, and in return, you have to preserve into perpetuity areas of open space and recreation.
But no houses is more open space than cluster houses, correct?
I will not argue that point, Your Honor.
Wise decision.
Yes, Your Honors, and no, you have never. This court has never ruled finding a comprehensive plan not in is not in harmony, and that a ordinance was in conflict. Superior Court has. I've noted the ALC Development Corp case in our briefs. I think it's directly on point here, while not exactly point for point. Ultimately, a city council proposed a zoning ordinance. Citizen petition came in and said, no, we don't want it. But the court found, well, no, this was in conflict with the comprehensive plan. And I think the Superior Court there noted two things I think are important for the court to consider. One, that, again, we're talking about this language in this paragraph about are allowed. They were discussing the use of the word should, and said, if the use of the word should in earlier sections of the plan were interpreted to make the plan permissive rather than mandatory, the entire plan would thereby be rendered toothless. notwithstanding the legislature's evident intention that comprehensive plans be binding and enforceable. And the court also found that, yes, the legislative body is not tied to, in essence, if you want to amend an ordinance that is in conflict with a comprehensive plan, you can do so only if you then go amend the comprehensive plan in tandem. And again, here, this circumstance, if Bath wants to amend, doesn't want any housing in the golf course district, they have to amend both the land use ordinance and the comprehensive plan and take language out that says cluster developments are allowed in this district.
What's the process for amending the comprehensive plan?
It's set out in state statute, Your Honor.
Does it
depends on-
require a citizen vote?
In Bath, it requires a vote of the city council. It depends on the municipality, the form of government, whether it's city council versus town meeting form of government. Thank you,
Thank
Your
you.
Honors.
Thank you, counsel. As is our usual practice, we'll take the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter. morning. You can be seated. The matter before the court is Cumberland 25-279. This is Alija Sejdic versus the Secretary of State. I see counsel are present, and I'm assuming ready to proceed. Before we begin the argument, I'd ask that both lawyers identify themselves by saying their names for the record together with the party they represent.
Good morning, Your Honor. My name is Robert Andrews. I represent Alija Sejdic, the appellant in this matter. And I have requested or asked for, with the court's permission, 3 minutes in rebuttal.
Katie Sibley for the Secretary of State, Your Honor.
Thank you. And Attorney Andrews, if you're ready to proceed, we'd be happy to hear your argument.
Certainly. Chief Justice Stanfill, may it please the court. On June 16th, 2000...
Well, I see that you let the green light come on right away. So,
I did, Your Honor.
Okay. So I understand some of your arguments that you're making. Some I'm not sure I understand. But when you argue that there's no evidence suggesting the physiological state of impairment beyond his admission to drinking and the smell of intoxicating beverages, but that's not really true. I mean, the whole point of field sobriety tests is showing physical impairment, especially, not just the HGN, but especially, and I know there's an issue as to how much weight was given to it, but the walk and turn and one-leg stand. I mean, what they're looking for when they talk about clues are evidence of impairment, and that's the test, right? Impairment to the slightest degree.
That is correct, Your Honor. It is those kinds of tests that demonstrate physiological impairment.
Well, and they happened here.
So I'm going to start with the validation studies, right? We know that validation studies for SFTs have been done. We know that horizontal, and I always get this wrong, stage nystagmus has an 88% accuracy rate.
But the issue here is probable cause, and we can get to how that's defined. It's not guilt as beyond a reasonable doubt. There was no evidence put in of some of that.
So the point is, Your Honor, is that those tests are not completely accurate, right? That other factors must be considered in the decision of whether probable cause exists. In this case, one of the conditions that was considered by the hearing officer was Mr. Sejdic's injuries. And for whatever reason, he excluded one of those tests, but not the other, given the problems with his ankle and a recent concussion, all of which affect the outcomes of those tests. And in my view, and Mr. Sejdic's view, are reasons to suggest that there isn't probable cause here, right? Because there has to be something more, right?
More than what? What we had here was an admission to having had drinks, 2 drinks, I understand, which I don't know, I've never seen an OUI case where the admission wasn't 2 drinks. Where there was admission to drinking, there was a strong smell of alcohol, and then we've got field sobriety tests in which I understand that the hearing examiner didn't place any weight on one of them, but nonetheless, we have 4 out of 6 clues on the HGN, 3 out of 4 on the one-leg stand, 4 out of 8 on the walk and turn. I mean, the issue here is not beyond a reasonable doubt. It's simply probable cause.
But what we don't have here are other significant factors with respect to physiological effects.
Like what?
We don't have red and glassy eyes. We don't have slurred speech.
So what?
And we don't have unsteadiness on his feet.
But if the issue is whether there is impairment, then isn't it more reliable to talk about evidence of impairment, i.e. The ability to perform these tests, than it is whether or not they have glassy eyes?
So, and the reason that I brought up the statistical arguments about why the tests are themselves not 100% accurate, and I know that this court has referred to them as highly accurate, there's substantial room in that 12%. That, and I'm focusing on horizontal stagnation.
12% defeats probable cause when you have all of these other factors that Chief Justice Stanfill has just identified, the admission to drinking, the smell of alcohol, He also was slow to stop for the officer, according to the officer. I mean, it's a totality of the circumstances test, right?
Well, I want to break down the totality of the circumstances, right? Because I can understand why one might say, okay, taking a risky action, say going around an island the wrong way, might be indication of intoxication. I have a harder time seeing that in the officer's subjective expectations that he didn't stop as quickly as I would have liked, and it was 25 feet.
But that's not all there is, and that's why it's totality of circumstances.
That's correct, but we're looking first at as probable cause develops, right? Which is what happens here. He pulls the car over because it's going 45 and a 35, which again, making the same analogy with respect to the not stopping within the officer's expectation.
So
again, it's hard to say.
Can I ask you, here we are talking about the merits of the case, about what happened or didn't happen, and whether it constitutes. As you know, here the hearing officer determining in the decisions say, I find it is more likely than not that there was probable cause to believe the petitioner operated a motor vehicle under the influence of intoxicants, then goes on to list all the reasons there. What are we, as the appellate court, to make of the fact that the hearing officer found that there was probable cause?
So I'm going to focus this part of the argument, Justice Mead, on what the standard of review is, right? And what we have suggested is that the standard of review is de novo.
For both factual findings as well as interpretation of law?
We have suggested that it is for both, although we understand that it's more likely to be bifurcated. The court has plenty of experience bifurcating this particular issue on a motion to suppress.
Well, we know what the standard of review is from the Administrative Procedures Act. It says the court, meaning the appellate court, may not substitute its judgment for that of the agency on questions of fact.
And the clear error standard with respect to questions of fact are consistent with the statute that allows us to review the decision. It is also consistent for de novo review, certainly of legal questions.
Okay, but is there anything in the Secretary of State's or the hearing examiner's decision in this case that you think is, as a legal statement, incorrect, as opposed to factual findings?
So I don't think that you can credit he didn't stop within 25 feet and the speeding allegation as evidence of physiological impairment.
But that's a factual finding.
Well, how you treat it is the legal aspect of it, which is why the Supreme Court has said twice now that de novo review is appropriate in probable cause findings when we're trying to create a consistent body of law.
But doesn't that mean, let's assume here that the Secretary of State had said, on these facts, I find that there's probable cause, and I define probable cause as a hunch. It need not be based on any articulable facts. We wouldn't defer to that definition. We would say, yeah, no, that's not what probable cause means. Is that what you're really arguing?
What I'm saying is you're correct. We wouldn't come to the legal conclusion that his hunch was probable cause, because we know that hunches can never suffice as probable.
Right, and if the Secretary of State or hearing examiner had said, that's how I'm defining probable cause in my determination, we would say that's error.
But we have a closer call of that happening here in this case, right? We have the physiological factors, which the hearing officer identified, and then we have what I'm going to call the non-physiological factors, the operation of the vehicle, contact with Mr. Sejdic, right? He's talking with Mr. Sejdic, and one of the things that I want to say about this is there's been some inference that he was non-responsive to the officer's questions, but what he was really having was a conversation, and he was incredulous.
Okay, when the 3 minutes remain, I want to make sure I really understand your argument here. The hearing officer made findings of fact, bullet point list, this, and this. And those facts, as the Act says, we can't substitute our judgment on those questions of fact. So we got those facts. And on the four corners of those facts, then we would determine de novo whether or not that constitutes probable cause. I think you are saying that going back to the facts, that those facts by themselves don't constitute probable cause, and there are other facts that weren't relied upon by the hearing officer that would undercut the conclusion of probable cause. Is that what you're saying here?
No, that's not what I mean.
Okay, because that's what it sounds like. Clarify for me, please.
That's not what I mean. What I mean is that there are, because of the court's decision where we've identified these three, I'm going to call it means of finding probable cause with respect to license holders who are conditional or commercial operators, right? We see from those cases that physiological findings have taken or can take a backseat to the non-physiological findings.
I'm not sure I
And
understand what you're defining as physiological findings versus non-physiological findings.
Well, what I'm trying to do is say that there's some evidence directly related to the body that might reflect on the state of mind, right? And as to there are things like stopping, and in this officer's training experience, he thought that was suspicious. I don't know suspicion of what, but it is.
Okay, so if we had a car that's weaving all over, the really classic, takes out the middle sign in the middle of the road, goes up onto the sidewalk, da-da-da, is that physiological or not?
I believe that's physiological.
Okay, because it indicates impairment.
Well, it indicates that you can't control the vehicle, which might be related to.
It might be an indication of impairment. It may or may not be enough by itself, but it is one of many factors one could consider.
Is an odor of alcohol a physiological fact?
I don't believe so, because this court has said mere consumption isn't enough. And the smell of alcohol is mere consumption.
I'm sorry, go ahead. It's a factor, right, among the totality of the circumstances. I'm struggling, and I'm going to maybe try to restate what Justice Meade said, and maybe I am not understanding your argument. Is your argument that as a matter of law, the facts here cannot constitute probable cause?
What I'm saying is that the court needs to create a standard of probable cause that requires or allows for the ability of a set determination, most likely made by the field by a law enforcement officer. And because we have three sort of means or three separate formulations of probable cause, it's now in the instance where you're supposed to have the most rigorous probable cause, we don't have that anymore. And that's what my argument is that we need to focus back on the idea, particularly in marginal cases, which is what I'm calling this case, that because we can't rely on that, we need the court to establish a standard that allows for specific analogies with respect to other cases.
Thank
the
you,
problem
counsel.
is that we're seeing those analogies by hearing officers being drawn in a way that is more appropriate towards the analogy for a patient. I see the red light is on.
Thank you,
I'm
counsel.
Finish my answer. Thank you.
And Attorney Sibley.
Thank you, Chief Justice Santo. Associate Justices, may it please the court. This case presents no reason for this court to ignore the scope of review as mandated by the legislature or deviate from decades of precedent. Sejdic's argument that he is entitled to de novo review of the administrative driver's license suspension is unpreserved, and even if preserved, his reliance on dicta from Bufkin versus Collins does not support his argument. In stating that probable cause is a constitutional standard, the Bufkin court primarily relied on 3 criminal cases, all of which involved the development of Fourth Amendment constitutional principles for use in future cases. This case involves no constitutional right and no development of any legal principle intended for future application. Indeed, Bufkin stands exactly for what this court has consistently affirmed: administrative decisions immersed in case-specific facts involving the marshaling and weighing of evidence and the determination of credibility are reviewed by appellate courts with deference. That deference is this court's substantial evidence standard. Ultimately, regardless of what standard this court applies, the administrative record meets the very low probable cause threshold. Sejdic was speeding late at night. He took an abnormally long time to stop his vehicle after reaching the roadside. He smelled strongly of alcohol. He gave inconsistent and unresponsive answers to simple questions. And significantly, he exhibited over 60% of the clues indicating impairment on the HGN test, which this court has previously recognized as the single most accurate field test, as evidence supporting probable cause and circumstantial evidence of intoxication. The totality of this evidence shows that the agency fairly and reasonably found as it did and does not compel a contrary conclusion. For these reasons and the ones cited in the Secretary of State's brief, this court should affirm the decision, and I'm happy to take questions at this time.
When we talk about the standard of review, I mean, we do have cases in other contexts of agency review where we have given some deference to agency interpretation of a statute, which would be really a legal question, right?
Yes.
Have we ever done that in this context, a review of what the term probable cause would mean?
Not a case that I can specifically recall off my head, but I believe the hearing examiner may have cited to it, I know it's been cited in other cases, is the reliance on State versus Webster from this court.
So if the agency in this case, and this is sort of the same question I asked Attorney Andrews, if the agency in this case has said, you know, I'm defining probable cause as a hunch that need not be based on, you know, any actual or articulable facts, and based on that standard, I find the following facts meet that standard, we would not accept that as a definition of probable cause.
I don't think so, Your Honor, but that's not what occurred here. As Justice Meade pointed out, as you pointed out, the hearing examiner went through all of the facts that were found and then applied this court standards. Did that rise to probable cause that Mr. Sejdic's senses were affected to the slightest degree or any extent? And the
So
hearing examiner
essentially,
said yes.
the review here is really not much different than we would in terms of reviewing, say, a suppression order or lack of a suppression order hearing from a judge who said, these are the facts that I found, and I find that that does amount to probable cause.
Yes, and I did point out in the brief, in criminal context, when reviewing a motion to suppress, there is a bifurcated review, but deference is still afforded to the judicial officer who made the finding of probable cause. After jury trials, this court doesn't substitute its judgment for the jury's findings as long as the record rationally supports those findings. Same here.
But
Does
we
substantial
need-
evidence support the finding?
We need to make sure that we're differentiated. You know, there's certain, for criminal cases, reviewing the finding of probable cause takes one route. This is actually an appeal from an administrative decision, and somehow these concepts have been merged. We need to be careful to keep them separate. And on the Bufkin case, maybe you can help me. I'm struggling to understand whether it has any application here. It was the Supreme Court was looking not specifically at the Federal Administrative Procedure Act, but a particular statute regarding veterans' appeals. They have a special rules for that. And then for some reason, which wasn't clear to me, Justice Thomas launched off into an analysis of probable cause that would be in the criminal context and did a partial review of that. And then I think the dissent actually fleshed out the rest of that. But the Supreme Court looked at criminal probable cause jurisprudence in addressing a civil case. I'll ask you, first of all, whether you understand why and how that happened, and secondly, whether we should draw from the criminal realm on our appellate standard of review on administrative matters. That's a long question, but there's a couple of questions within that.
I will do my best to answer it, Your Honor. Short answer is Bufkin applicable here? No, not at all.
Well, let's push back on that.
Yes, Your
The
Honor.
real decision that we should be looking at in the Supreme Court is Ornelas, which is 517 U.S. 690, which is also a criminal context. But if you look at cases from other jurisdictions, other states, where they've looked to see what the ultimate determination of probable cause should be in the civil context, I stopped looking at Illinois, Kansas, Missouri, and Ohio, all saying we use the Ornelas standard, which is the ultimate determination of probable cause, because why would there be a different one in the civil context? And it's constitutionally required if you look at Ornelas. So isn't that what we're looking at, the progeny of Ornelas here?
No, because we're not talking about a criminal case here. We're talking about.
I'm talking about all these civil cases in all these other jurisdictions. Are you saying we should deviate from these other courts that have said, oh, yes, the Supreme Court's told us and we're going to apply that?
I feel like we're conflating two different issues. We're not saying that that probable cause is a completely different standard. But what we are talking about here is an administrative context. We do not have a decision where, in Chief Justice Stanfield's hypothetical, a hearing examiner has just decided to create their own standard.
What you're really saying it doesn't matter is because the standard that was applied is in fact the same standard that the court applies.
It doesn't matter for two reasons.
In the Fourth Amendment
Yes,
context.
Yes, that
Yes.
is one of them.
I get that.
But suppose the court defined probable cause correctly, but then the facts were just, he was speeding and he drank one beer, and the court says, the hearing examiner says, that's probable cause of impairment. Couldn't we, even if we defer to the factual findings, find as a matter of law that's not probable cause of impairment?
Well, as part of this court's review in the administrative context, it is a review for an abuse of discretion or an error of law. The court could determine that as an error of law. Here, there is far more than that. It's the combination of the speeding, the time of night, the slow stop, the smell of alcohol, the different admissions, one of them being the, as Chief Justice Stanfield pointed out, the very typical OUI admission of the 2 beers. We have the non-responsive answers. I had 2 beers. I had it at this time. Now I don't remember. How would you rate your sobriety? 2 beers. Wait, no, I rated this.
So your position is that, deferring to the factual findings, there was no legal error, but you agree that if those facts as a matter of law didn't establish probable cause, that second issue would be something we review de novo? Is that fair?
The court would view it under its same standard. Substantial evidence in the record, abuse of discretion, or error of law in the court's hypothetical if the only factor supporting probable cause for intoxication was speeding and slow to stop. I think this court could find that that was an error of law.
Just to boil it down maybe to one sentence, I think what you're saying is we accept the findings of fact and we look at that with a fresh lens, de novo, and say, is that sufficient for finding probable cause? Because that is an issue of law, whether or not the facts constitute probable cause. Am I?
No, this court does not review the facts de novo.
No, we're not. We're accepting them. We're accepting the facts. Not generically speaking, we get a case, we have the factual findings. He drank 1 shot of something and had a meal and exhibited certain factors, and from that, the hearing examiner concluded that he was impaired. So we're not looking at the facts of what he did. We're looking at the hearing examiner's decision that's saying 1 + 2 + 4 = 1 equals probable cause. And if we looked at those same facts and said,
As found by the hearing examiner.
as found by the hearing officer, and found that does not equate as a matter of law to probable cause, then we would be able to make that finding as a matter of law.
If the court found that as an error of law and that the hearing examiner's decision was not supported by substantial evidence in
Okay,
the
so
record.
we're saying the same thing, I think maybe a little bit of different language.
Just so I'm clear, that's a sufficiency of the evidence claim, isn't it? Isn't that what we're talking about? We
Well,
take the facts
substantial
as found.
Substantial evidence is different from sufficiency. We don't do sufficiency in the civil context.
And what we are, again, here, we're in the administrative context where this court has repeatedly given and affirmed its standard of review. It's contained in Title V, Section 11007. It's the substantial evidence in the record.
I think we're all saying the same thing.
So let me move on to a separate question. How impaired under this statute does the driver have to be? Itsy bit impaired?
This court has said senses affected to the slightest degree or any extent.
And when I was in my driver's ed class, they said, you know, don't have one drink because your braking time will slow down. So is that enough under this? I mean, we're not looking at .08 or anything like that. We're looking at the slightest bit of impairment?
And that depends on the totality of the circumstances.
So if it showed that you weren't as sharp as you would be had you not had that one drink, that could be enough?
It would actually depend on the stop. To take the facts of this case, let's say, so we'll start with Mr. Sejdic was speeding. It was late at night. He took a long time to slow down. Officer approaches his door, but there's no smell of alcohol. There's no other indications of possible impairment. He's not giving inconsistent answers. It might be then more difficult to say, okay, I'm now leading up to an OUI investigation.
But the standard of impairment, I mean, you've probably got it etched in your brain from all the cases, whether the driver's physical or mental faculties have been impaired to any extent or to any degree.
Correct.
Black letter law in the state of Maine. So for your finale here, is you've got 2 minutes left here. Let's say we're looking at that, and you would be, I think what you've been trying to do is to hit the bullet points as to why the finding of impairment is justified upon these facts. I'll say to you right now, what are the facts in the record here that we're bound by that justify the finding of impairment?
Well, to start, to lead through, to build to the probable cause, speeding late at night, slow to stop, smell of alcohol, admissions to alcohol, inconsistent answers which show some mental impairment, and the performance on the field sobriety test, even excluding the one the hearing examiner didn't conclude, were significant in the amount of signs that it showed of impairment, specifically the HGN, which, as I said in my opening, this court has found to be accurate evidence of supporting probable cause, as well as circumstantial evidence of intoxication. And here we have over half the clues that indicated impairment. Thank you, Your Honors.
Thank you. Attorney Andrews?
The court has pointed out, the Supreme Court did initially create this bifurcated standard for probable cause in Orleans. Now, more recently, last March, the Supreme Court has then used the probable cause analysis to define how it goes about its appellate review of statutory standards in the civil context. In each instance, and while it's hotly debated in Bufkin.
Well, I understand, but isn't it true that it's true, the probable cause standard, there's nothing in this decision that would indicate that they weren't applying the same probable cause standard. The hearing examiner wasn't applying the same probable cause standard that we would apply in reviewing, say, a suppression court in a Fourth Amendment context. There's nothing about it that says it's different.
Well, I disagree in the sense that it's so similar to pacing. And the reason that I object to that sort of analogy for all probable cause standards is because I think there are various degrees of strictness that have to be adhered to in the probable cause determination. And when we have a probable cause that is supposed to be based on the physiological effects of alcohol, I think that we have to be stingy in how we guard what probable cause is and what reasonable inferences are. I mean, in this case, we're looking at 25 feet. For an officer who's been an officer for about 6 months, the benefit of training and experience, okay, yes, something can be said about that. But when we start talking about in my training and experience, what we're hearing is that checklist. And we need to be careful when we apply just the checklist, because when we have a marginal case where someone who's been injured, it might not be evidence of intoxication.
But isn't that the point of looking at the totality of the circumstances? It wasn't just the slow stop. It was an accumulation of facts that came out during the course of the interaction with the defendant.
And some of which have been credited in this court's decisions as valid. And the problem for us, the problem here for us is that it required a test and he didn't take it, which justifies the finding. And because it justifies the finding, that has collateral consequences. And from our perspective, those collateral consequences are necessarily to be protected through due process. And we think that that's really the purpose of the administrative hearing, is to ensure due process, that his license isn't being taken without sufficient cause. And in this case, I guess it would be probable cause. And from our perspective, we need this court to say, we have to return to the physiological factors, and we have to be strict in what we say those are when we're relying on what seem to be non-physiological factors, like the subjective views of the police officer.
Thank you, counsel. As is our usual practice, we'll be taking the matter under advisement, issuing a written decision in due course, and with that, we'll be in recess on this matter.
All rise.
And good morning. You can be seated. And the matter before the court is Kennebec 25-281, State of Maine versus Kenneth Marin. I see counsel are present. I'm assuming you're ready to proceed. We are being streamed on the web, both by audio and by video. And I would appreciate it if before we begin the argument, you could each identify yourselves by saying your names for the record together with the party you represent.
Jeremy Pratt on behalf of the appellant, Kenneth Marin.
Shannon Flaherty for the State of Maine.
Thank you. And Attorney Pratt, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you. Good morning, and Madam Chief Justice, Associate Justices, may it please the court. This case turns on an evidentiary error that undermines the fairness of the trial. The trial court admitted a sexually explicit photograph, State's Exhibit 9, without any permissible evidentiary purpose.
Well, I see that the green light is on, and you've argued that the GSA doesn't have a mens rea requirement, but that wasn't the only charge. I mean, there were other charges that did have a mens rea requirement.
That's correct, but clearly the GSAs were Class A's. They were the most serious of charges. They were the ones that resulted in the longest sentence, and those are the cases that the evidentiary ruling should flow from. And
ignore the fact that there were charges that had a mens rea requirement?
No, not ignore those mens rea requirements, but when the photograph in particular is so inflammatory that it should be guided by the standards set from the Class A GSAs, not on the lower, lesser charges.
Is there any case law saying that we would bifurcate that analysis? In other words, that if something is relevant to one charge but not another, but you know, that's if it's the one that is not relevant to is the more serious charge, that would somehow be sufficient to exclude it?
No.
Okay.
I was not able to find any cases on that particular topic, but I was also not able to find any cases in regards to when there's no intent element, whether or not intent can be used or not in a case. So we're asking the court to do a number of unique things in this situation. But even if the court were to find that it would be appropriate, given those other charges and the mens rea elements in those, to admit this for intent, we would argue that it should fail under 403, the balancing test, not just under 401, under the relevancy test.
Do you feel that the photograph had some probative value?
No.
None at all?
None whatsoever, and let me explain why. The photo did not depict the parties involved in this case. It depicted legal conduct, which obviously was different than what's in this case. But most importantly, we do not know the time frame of when the photo was viewed. Our argument is you cannot show intent or motive by something that was viewed after the fact. So this was a historic report of a crime, and the photo was found much later afterwards, and there was no evidence ever presented of when the photo was viewed. So because we do not know that, you cannot say that intent or motive existed before or during the time of the alleged offense that came from this photograph.
But you can't retroactively apply intent, motive, or relationship or any of those other sort of windows to get stuff like this in?
That's what we're arguing in this case. And I would also say that the state relies heavily on the caption of the photo, which is "Oh, Grandpa." And the alleged victim in this case referred to the appellant as the German word equivalent for grandfather. But we would point out that also in the record is that everyone called him the German equivalent of grandpa, so that it was not unique to this particular individual. So that if it were a unique name or a unique word that the alleged victim called the appellant, then it might be more appropriate to include. But because this was a universally used name, that it would not be.
So if you find no probative value, we don't slip to the second level, which is whether it was unfair prejudice.
That's correct. But we would find, even if the court found that there was probative value, then we would also say that the unfair prejudice was so extreme. In this instance, we think that the real reason the photo was admitted was not to show anything else except propensity evidence. That he has by viewing this photo, he has a predilection for having a sexual interest in young ladies. And although the photograph does not depict someone who was of illegal age, it was someone who was depicted to be very young. And also that there was a predilection for a grandfather-granddaughter sexual fantasy.
But the state's going to argue, I assume, that there was probative value, suggesting not necessarily predilection, but the motive that he might have had previously to engage in these acts with the victim.
So when we would argue that the cases that I could find that talked about motive, it was when it was related to that particular individual. Again, these do not depict, it does not depict someone who is underage. It does not depict the alleged victim in this instance. So I'm not sure how it depicts motive when it involves two adults, not an adult and a child.
Are you familiar with the case of State versus Vroman?
I'm sorry, could you repeat?
Are you familiar with the case of State versus Vroman, which I think was a 2013 case involving a former trooper? But in that circumstance, there were... Vrooman.
I thought you were saying Broman, and that's where I was...
Oh, so, okay. So you are familiar with that
I am
case,
familiar with
which is somewhat akin to this from the standpoint of there being images that were found on the computer that indicated an interest in younger women. And in that circumstance, that was at least there was reference to those images that were admitted into evidence for purposes of establishing motive and intent and opportunity.
Yes, if I recall correctly, though, and I don't have all of Vrooman right at my fingertips, I'll readily admit, but I thought that also involved I thought that the images in those were illegal images, not legal images. Am I completely off basis on that?
My recollection is they were legal images. They weren't the illegal images.
Then I will concede that I don't recall Vrooman well enough to make a distinction at this case off the top of my head, and I apologize. I do not believe this state cited that in their brief. If they did, I missed that, and I did not cite it in mine, so I apologize. I'm not able to answer that as thoroughly as I would like.
Can we go to the second issue about the uncharged conduct? And counsel, thank you, by the way, for your clear explication of the difference between 401 and 403. And I mean that actually, because I find that people mush those together an awful lot. But to the second issue, I mean, is that even preserved? I mean, the uncharged, the testimony about the van.
Well, we would ask for you to view it as an obvious error standard. The defense clearly did not object.
Okay,
if you were asking whether there was a waiver.
Yeah, because then we have a specific instruction that is, emphasizing that the conviction can only be based on conduct that occurred in Kennebec County, and that was in order to deal with that.
Well, I think in this instance the danger is he must have done it out of state, so therefore he must have just done it in Maine, is the danger that the appellant faces.
But isn't this testimony where it's like he's done it many, many, many times in any event? So what difference does it make whether it's out of state or?
Well, in this particular instance, it was brought up to the jury, I believe, 37 times involving the camper van and out-of-state activities.
Well, I don't understand why it isn't waived, because the court specifically asked, do you have any objection? So we know it's on his radar screen. He's making a party presentation decision, and he says no objection. Why isn't that waiver?
So I had anticipated this question. From you in particular, I anticipated this question. We would argue that this was not waiver, but forfeiture. And the reason why is that the defendant did not affirmatively take any steps to agree to the admission of it. He simply did not object. And we think that there's a distinction that the court should acknowledge. It appears...
But there's the did not, isn't it different to... I don't disagree with you that I think I've kind of fought hard for the fact that just simply failing to object is not a waiver. But on the other hand, if you are affirmatively asked, do you object? And the answer is no, isn't that a waiver?
We would argue no and ask for that to be forfeiture because he did not agree for it to be admitted. Simply not objecting is different.
So every time somebody admits a piece of evidence and the court goes, any objection? And they go, no. On appeal, all of those can be reviewed under obvious error?
We think so. It gives us the worst standard and the higher bar to have to cross, and so that's what we're asking.
Actually, the worst standard would be.
But how can no objection, I mean, you said he didn't affirmatively agree, but if you don't object, aren't you agreeing?
Our argument is...
If you explicitly say you don't object, let's be clear about that.
Well, isn't there more here than him just not objecting? Because didn't he agree? Actually, there was a talk of what the jury instruction was going to be, and then there was further discussion, and there was an agreement that what they were going to put it as a jury instruction was not going to be handled in the same way. They then reverted to the events had to take place in Kenneth County or Maine, and that would be the way in which it would be presented to the jury.
You can now answer the 8 questions that were just asked.
So I do agree that it was in the jury instructions as well. I mean, a somewhat limiting instruction was in the jury instruction that was agreed to by the defendant. If I may, instead of directly answer that, maybe take a different tactic that I think loops back to that, which is, I think then the argument would be that this, which I was expecting a question about whether or not this might be a more appropriate PCR issue, the failing to object to the out-of-state conduct. And we would argue that there's no logical reason as to why that would not be objected to on the record in that moment, and that the Court for Judicial Economy should consider it, as this Court is allowed to do so, of whether or not it was appropriate to admit this material or not, regardless of whether or not there was a waiver.
I think we usually handle that in it's waived, but we note that even if had it not been waived, we would not have flipped on that basis, right?
Which takes us to State versus Hunt. Do you want to address whether or not it's distinguished from that circumstance?
Yes. So in State versus Hunt, which if I recall correctly was Your Honor's case.
That's my recollection also.
So the hunts on the set, I'm assuming the court is referring to the section where you are citing Krieger as sort of a block quote from Krieger, which I think what is interesting about that is Hunt involves GSAs that have no intent, but that the citation is directly from Krieger, which involved crimes that had intent. The court never has directly addressed the issue that I'm raising, whether or not motive is relevant to no intent crimes. And even in Hunt, that was not specifically addressed. I don't think the court has had the opportunity to ruminate on this unique issue. I've not found any cases anywhere in Maine that specifically address this issue. I have found cases that imply that it would have no relevance, specifically Dilly. I also then cited to a case in both Louisiana and Ohio, which also suggests that when there's no intent, that motive is not relevant.
And that's what you would have us hold here?
Yes.
But the problem you've got here is that there are charged crimes that do have intent as an element. And I understand your argument that the GSA is the more serious and more concerning.
And there's no request for limiting instruction saying you can only consider it for this count and not that count.
There was not. But it is so prejudicial. So also we would say under 401, not relevant because of the intent issue. That I think it's worth stressing again that on the Class A charges, he received a 25-year sentence, and on the lower charges, may I just finish the one thought?
You may.
The lower charges that have the intent element, he received a 10-year sentence, and that the guiding principle we would ask this court to adopt is that the lead charge should be where the evidentiary rulings flow from. And if the state does not want to have that, they should file a motion to sever the charges. Thank you.
Attorney Flaherty.
Chief Justice Stanfill, Associate Justices, may it please the court. This court should affirm the trial court's legal findings and the jury's verdict for 2 reasons.
Well, I'm going to jump right in since you left the green too, and follow up on the point just made by Attorney Pratt. I mean, the most serious charge in this case clearly was the GSA that made the difference of a 25-year sentence versus a 10-year sentence on the Class B unlawful sexual contact.
Yes.
Why I mean, should we look at the evidentiary rulings? If something is, assume he's correct, that it could have been admissible as to the count, the non-GSA counts, but that it would not have been relevant, and I know you may not agree with that, but assume it would not be relevant to the GSA counts. Should we, he's suggesting the evidentiary rulings really need to flow from what is essentially the lead count, what we would call the lead counts when it comes to sentencing. We do it all the time.
I think when it comes to sentencing, that might be appropriate. I think while there might be more counts that are serious, more serious than others, I don't think that necessarily saying that certain evidence should come in as to one count and not other counts would really be conducive.
Do you deal with that simply with limiting instructions?
I think you could do a limiting instruction.
But it's pretty hard to unring the bell. I mean, if the evidence is in.
Well, I also think, to go back, and this doesn't exactly answer your question, but there is significant precedence in State v. DeLong, State v. Hunt, and other cases, even State v. Parsons, where even with gross sexual assault or something that doesn't have a mens rea, that evidence of motive, intent, really grooming would be admissible as it goes to the relationship. So to somewhat answer your question and also not, I don't understand how in a case where there is usually so much evidence of how the relationship started, how it began, how manipulation came in, if none of that was admissible, if none of that was relevant simply because there's not a mens rea, that means that in gross sexual assault cases with children under the age of 12, this court would have to find that any evidence of buying presents, grooming, sexting, things of that nature would not be admissible simply because there's no mens rea. I think that's counterintuitive to not only the trial process, but one of the most serious charges that we have, other than murder and other violent crimes, is sexual assaults against children under 12. And the idea that evidence of how that starts would not be admissible seems counterintuitive really to the justice system as an entirety. But that would really be the state's argument there. Just because there isn't a mens rea doesn't mean that motive isn't relevant. The state never has to prove motive. That doesn't mean we don't try. Juries really care about motive. They care about how things start. They care about how relationships start, even if it's not something that's necessarily part of an element or a charge.
Do you want to deal with the waiver argument?
I love the waiver argument. I think it was waived so many times, with all due respect to counsel. I think that if you look at the case, I think it's waived. The state filed, not only was there no objection, the state filed a motion well before the trial with its intent to bring in uncharged conduct, because I have done it before, and I've also followed some of the case law about specific unanimity. I want to make sure that we have everything that the law court wants so that we can try to avoid at least specific appealable issues. So the motion had been filed prior to trial. I think it was filed even prior to jury selection. We are there the first day of trial. I think this is on page 5 or 6 of the transcript, and trial counsel didn't object. Then at jury selection, again, when asked, do we want to put the specific unanimity in there? How do we want to address it? Again, no objection. Let's just do a very much limiting. What I would go even further with, though, and I do respect the briefs by appellant about how many times I mentioned the camper van, but I think it cannot be ignored how many times Mr. Banda mentioned the camper van, how many times the defendant, when he testified, mentioned the camper van, and the trips, and going to Disney, and going to Storyland. That was part of their defense. They admitted evidence actively about the uncharged conduct in a way to try to help their defense.
Well, not really the uncharged conduct, but the fact that they took camper van. I mean, the uncharged conduct is that illegal acts occurred during the...
There were some illegal acts, but a majority of the uncharged conduct, there was some illegal acts, potentially touching, things of that nature, but a lot of it went to these trips that they went on, that they shared a bed together, that really reinforced the grandson's testimony. The grandson's testimony that they never, the defendant, when he talked to police and when he testified, we never shared beds, we never touched. I never even called them pet names, really. I was very standoffish. What the uncharged conduct and what happened outside of the state of Maine did was show, in many ways, motive, pattern, and relationship, but it showed that the testimony or the prior statements by the defendant were inconsistent with the rest of the evidence in the case. They did share a bed both at the basement, at the house, and in the camper van. So the idea that it's not waived when Mr. Banda admitted his own Defense Exhibit 1, which was the CAC interview of the grandson, where they talk about what happened in the camper van, is counterintuitive. It was waived not only when directly asked, do you object? No, I don't. And then asked again, do you want to do anything specific with jury instructions? Let's just do this. That camper van and those trips and what happened or did not happen, because the two sides never agreed on what happened either in the basement or in the camper van, but what happened on those trips was brought up by the defense numerous times as well.
Well, what do you say to his argument If you don't look at these things under obvious error, we're just going to have to bring them up again in the post-conviction review.
Everything is always going to come up in post-conviction review. Everything's going to come up on appeal. Even if I do in a completely perfect trial, with all due respect, there's going to be something to appeal. If I hadn't brought in State's Exhibit 9, if no uncharged conduct came in, if I never slipped up and said something wrong in a closing, an opening, or a question, something will be appealed and something will be PCR'd. I would almost guarantee it. If I'm wrong, I apologize. But the idea that we have to do obvious error because then we'll just be here again for a PCR could be argued in every single case and probably is in many ways.
Well, but can we really say that this was a strategic decision when he said no objection?
I think we can. I think that Mr. Banda wanted to talk about how much Mr. Marin took care of the named victim. I think he wanted to talk about how many times he paid for her summer camp, because that's why she made all of this up, is because for the first time when he said, I'm not paying for anything anymore, don't call me Opa, during the Salem trip, that's when all of a sudden she decided to come forward with all these allegations. I think it was completely strategic. I just don't think it worked.
That last point you just made in terms of him, the record reflecting that he indicated she could no longer call him Opa. What's your response to the assertion that the photograph with old grandpa had no probative value?
I think it has significant probative value for many reasons, and I will answer that really on 2 points. One point, when it comes to the relevancy, I think that what is always missing, at least in this particular case, is that the defendant in this case said that he was asexual, that he had no sexual engagement whatsoever, that he physically couldn't do it in many different ways, couldn't engage in that conduct, couldn't even have those types of thoughts. So the idea that he has these images on his private computer attached to his TV in his private room, as he testified to during the trial, and it counteracts his entire argument that he could never have done this because he has no interest. It doesn't exist for him. So I think that makes it probative. It goes directly to his defense that was brought up not only with the police but also at trial. When it comes to the old grandpa portion, I think it's also important, maybe a lot of people called Mr. Marin Opa, but the named victim was the only person told to stop calling him that. That's a very important fact. That was the breakdown of the relationship. When he said, don't call me Opa again, he specifically, even on his own testimony, said he might have been too harsh with her because he broke that relationship in half. He broke that by telling her, don't call me Opa, and indicating that it was an important relationship between the two of them. I don't totally agree.
What does that have to do with the photo? I'm not following.
When it has to do with the photo, the idea that their relationship didn't matter, that the photo was not in itself unique enough to be more probative than prejudicial, because it shows the relationship between the two of them was a grandfather and granddaughter relationship.
How does the photo show that? The photo wasn't a picture of them.
It doesn't have to be a picture of them. State v. Parsons, very clearly, this court has said that photos that go to, even if it's not the two parties involved, photos that depict the relationship can go to the motive, the pattern, or the relationship between the parties. That photograph depicts the relationship between Mr. Marin and the named victim in this case, very specifically, because even though it might not be a young child, it's still a female, and it's a very specific caption that says, oh, grandpa.
Well, I'm not sure I follow. It might depict something. It might depict a predilection on his part, but it doesn't say anything, does it, about this victim and the relationship with her?
I would disagree, because the relationship between this victim and the defendant is a grandfather-granddaughter relationship. And what I mean, going back to what happened in Salem, what broke the relationship, or what is allegedly the trigger to why she came forward, was because he said, no longer call me that. Don't call me that anymore. It shows how that relationship, that grandfather-granddaughter relationship, was a key part of their interactions together, which I do think makes that photograph very unique, because if the court remembers...
Follow the first part, but I'm not really following how breaking that relationship makes the photo more.
I think that it just shows, I think when I say breaking the relationship, I'm going more back to the argument that Mr. Pratt made, saying that everybody called him Opa. So it's not a special relationship, it's not unique to this particular child. I think it is unique, because it is something that he deliberately took away from her. So to say that everyone calls him Opa, it doesn't matter, it's just what they call him, I don't think that's relevant, or I don't think that's true based on the evidence in the case, because it was something special and unique between those two people, because he told her no longer to call him that.
If we accept that there was this unique relationship, what about the point that opposing counsel was making with regard to not knowing when that picture was amongst the things that were in the computer of the defendant? The temporal issue.
The time issue.
Right.
I think it's a relevant and important part of it, but I think that when you look at it, again, it goes to the specific nature of the relationship. And when you look at State v. Parsons, what State v. Parsons said, this court said it doesn't necessarily have to be the parties involved. It just has to depict what the victim is alleging happened, if it's consistent. And that picture, State's Exhibit 9, not only depicts a sexual act, which is what was alleged and found by the jury happening between the defendant and the victim in this case, it again depicts their relationship, an grandpa relationship, a grandfather-granddaughter relationship, which is why I do think that it's probative. And I think it's also important to note that, again, this is an abuse of discretion review under 403 from the state's perspective. So this court would have to say that Justice Mitchell made an abuse of discretion. The state tried to get a lot of photos in.
So it doesn't matter when the photograph was put on and when he had possession of the photograph? It could be long after the conduct, right?
It could be long after the conduct. It could have happened during the conduct. I think that Justice Mitchell made a good point when he said that the other images weren't connected enough because we didn't know necessarily the time frame. They're just these photographs that allege sexual acts that are alleged to have happened. The difference with this particular photograph is the caption. If it said, oh, friend, or oh, my love, or something like that, I don't think it would have come in. But because it says, oh, grandpa, that is unique and specific to the relationship between the named victim in this case and the defendant, which does make it probative and goes to the exact relationship that was at issue. Again, I think it goes to two different parts of that. One, the relationship as outlined by State v. DeLong, State v. Hunt, State v. Parsons. But again, it also goes to the fact that this defendant said that not only was he not sexually attracted to children, but he has no sexual desire at all. So even if this is 2 years in the future, even if this photograph was, say we had evidence that it was
That would be the argument for any photographs of sexual activity as opposed to the, oh, grandpa
That is
caption.
true. And that would have been nice to get them all in, but I didn't, and I understand that. But that is a valid point. But at the same time, the argument that he has no sexual desire at all, even if you take all the photographs or just the one, that also goes to why it's important for the photograph to be admitted, because he states over and over again he couldn't have done this because he has no desire whatsoever. That's what he talked about at length with law enforcement during one of his interviews, actually I think all of his interviews, and then also when he testified. If there's no further questions, thank you very much.
There don't seem to be. Attorney Pratt?
The photograph was admitted before there was any evidence presented at trial that he, the defendant, was asexual or had no interest in sexual
Wasn't that part of
activity.
his interview with the officers, though?
It was part of the interview, but I do not believe that that portion was played.
So it
for-
wasn't dependent necessarily, though, on him testifying, was it?
It was, because I do not believe that it was presented at trial until it was, until he testified to it. Although it was part of his recording, I do not believe that that was presented in the state's case in chief. I believe that and if I'm wrong, I apologize, but I believe that they first admitted the photo, and then the evidence came in about his asexual defense. And if that's the case, I would argue the same thing that I argued about the temporal nature of the photo, which is you cannot create a ground after the admission of something. Additionally, I would say that the state said that one of the reasons that the photograph was admissible was that it was consistent with the alleged criminal activity in this case. We would argue it's not. The photo depicts two consenting adults. That is not what is alleged in this criminal conduct. The name on the photo is not unique. It does not identify anyone. It is not the parties involved. We do not know the temporal nature of it. We would say it is not consistent at all with the alleged criminal activity here. I'm happy to answer any questions, or I'm willing to rest on that rebuttal. Thank you very much.
There don't seem to be any. Thank you. Thank you, counsel. As always, it really is a pleasure to hear both from Attorney Pratt and Attorney Flaherty. So we appreciate the argument here this morning, but as is our usual practice, we will take it under advisement and issue a written decision in due course. And with that, we'll be in recess for the lunch period.